trying to find the substantive level and the institutional level. There is a problem, because there is a problem. I met this, what you are doing now, I met it 20 years ago, and I think there is a problem because there is no subjective element. Anything could be religious. So if you say this is religious, this is not religious, even if you try to make a criterion, or a substantial criterion or a institutional criterion, there is a problem because you don't make space for subjective. There is a subjectivity. This could be religious, this could be religious, anything could be religious or not. So this is one comment and question. Concerning Karin, I think Ruti will also have the issue that you ask, that you present, the problem. I think there is implicit thinking in your paper that the men should pay and the woman should receive. If the woman is poor, so the woman should pay more. But why we are not in a position that if you want to talk about equality, so sometimes also women should pay. But this is not possible for Muslim because they are applying some in Sharia law, and the Sharia law is not possible. But it will be possible if they abolish Sharia law or Jewish law or this religious law. So I think the problem is to speak about equality. It is not real equality, because real equality should be according to the concrete situation of women, but also of the men. There could be a situation, even if it is not statistically, if it is not a large extension, there is no extension of this phenomenon. There could be a situation where men will be very, very poor and women very, very rich, even if it is hypothetical. But when we are speaking about equality, should be equality in concreto, in concrete case. So this is one remark and one. And another also remark: the problem to make this to comparing Sharia court and civil court is a problem that there is no access. So we know about family court, and Ruti wrote maybe 20 years ago about the problem of access, and you say, well, 0.5% of access of family court. So we know about family court what the family court want to show us. We don't know a lot of things. If it is 0.5 of decision, could we really make a comparison? So this is, and the last question for Pamela. Do you think maybe the key for this resolution of the new multiple recognition of parenthood, maybe, because if you use the apotropsut, maybe it is more limited, maybe should be resolved maybe by the best interest of the child, but the problem is the conception of the judge are limited to the conservative family, but I think it will be more useful maybe. Oh, thank you.
Okay. Thanks. Just quickly on your last point about accessibility to family courts, it's really, the situation in Israel is completely absurd. And there is an ongoing petition by the Brackman Center in the name of several scholars to have access to, even to conduct research, even not to publicize all the decisions. And we were just, as the expression in Hebrew goes, thrown down the stairs by the justices of the Supreme Court after agreeing to order that each family court judge would publish one decision per month. That was the huge settlement, so-called, and even this is not really being followed. To your question about how does the what is the case law with relation to these non-state private marriages? It's the thing is that, as I showed, they actually fall into either of those regimes, either of the opt-out regime, the de facto, so they are regarded as de facto relations in terms of their internal rights and obligations vis-a-vis one another, or vis-a-vis the state or third parties, or some of them, but as we show, less than 50% of them, supplement their private weddings by registering as married through the civil marriage which is conducted outside Israel. So their situation, the questions of rights, obligations, protections, or all those ramifications of quote-unquote status, and I put a question mark with respect to the question of status, but the ramifications of status are more or less settled in. There is one angle which I didn't talk about, and again, it's a conversation for a different topic, and that's the issue of criminalization of conducting the private weddings, because it can carry a penalty of 2 years imprisonment, and it's never been enforced. I mean, we'll just put it aside. But I also wanted to comment on Karine. I mean, I can't resist. It's fascinating what you're showing, this paradoxical and Ido and the judge. Yes, thank you. It's so to paradoxically show that the religious system is in fact becoming more favorable and more substantively egalitarian towards women. But on the other hand, it's really not surprising, because as I also showed in a while ago with respect to Jewish women, not with respect to Muslim women, this, what you described as the false equality and seemingly imaginary egalitarian, or in Hebrew I try to call it the equalitization methodology of the civil court. So they're simply following in these footsteps, and we see this all around issues of family court with respect to child custody issues as well. But what I think would be really interesting is to show the comparable development with respect to rabbinical courts, not in wife maintenance or spousal maintenance or alimony or support, but with respect to child support, where they present themselves now as being much more, what's the word for this, nadiv, generous, thank you, much more generous towards children and women. Naturally, that's most of the time the recipients of the child support for the children, much more generous and offering higher awards, higher child support awards than in secular, than in family courts. So it would be really very interesting to compare that.
Thank you, Musa, for the opportunity to clarify myself. Or clarify my project. My project was not to define religion or to give a set of necessary and sufficient conditions for what is religious and what is not, and to say that this court is religious and the other court is not religious enough or so. What I was trying to do is to take a phenomenon, which is the way rabbinical court functioning within Israel, and notice that under the umbrella of identifying themselves as subjective religious courts, they are doing at least three separate things. So for any subjective aspect of religiosity, I would ask the subject, whose own subjective view is considered, in what sense you mean that your norm or your judgment or your publication or your anything is religious? Is it in that sense, or that sense? So I think that having read your dissertation, trying to analyze Sharia courts 20 years ago, I was not trying to tackle the way we can understand a court as religious or not. And in a way, I'm flirting with the idea that even civil courts are religious in the very same ideas, but this is for now.
I just wanted to ask a few quick questions and then respond to Musa's comment and to help me clarify something. First, with regard to Karine, I was interested in access based on not only access, whether it's published, but also language. I mean, I find I feel so restrained because I wondered about the Israeli judges in the civil courts. Can they read the Arabic language decisions even? So how could they possibly even understand what's going on? I mean, it's so that it's very difficult. I wanted to comment on Ruth's presentation just to add that I know a number of rabbis who consider themselves liberal-minded, quite a few, and I've had discussions with them who are afraid of the illegality because of other things that they do. They would be happy to officiate at all sorts of marriages, except they actually think that they'll use the fact that they did that to prosecute them when they try to fight for other things. And so the illegality may not be deterring the people themselves, but it is deterring many liberal rabbis from doing it. Not many. No, there aren't that many liberal rabbis, but the ones that I know. And one comment. No, I've forgotten the last comment. That's okay. That's okay. We'll just skip it. And then in terms of Musa's comments about best interest, right? So my first response would be like what you already said, which is that, well, best interest is not creating a lot of progressive attitudes within the courts, but also I want it to be a status. It can't be parenthood because that has that religious meaning, and that's not gonna. It might be good for the U.S. or for Europe, but it's not going to work in Israel. So I think it needs to be this guardianship kind of status. Like I call it guardian functional parents. It's a little different than just any guardian. But I think it needs to be available for registration or court order beforehand, but maybe also as a best interest, like maybe afterwards. But once we create the status, maybe it'll be more accessible. That's what I wanted to do. That I agree with you. If we don't start somewhere, we're not getting there. Okay.
Thank you so much. I have much to say. I'll start with Ruthie. I want to be insistent that our research is still very surprising, even if you take into account your research on the civil law with civil law courts with regard to Jewish women. And why? Because the civil courts did go a long way towards women. And we know that, for example, Jewish law includes lots of male defenses that may exempt men from paying maintenance. And so if a woman is adulterous, rebellious, and whatnot, she loses maintenance. So the civil courts told many husbands, no. First you play, you pay. If you also go out with other women, then your wife is entitled to go with other men and still get paid, right? You will finance a romance with the other men. And also, in terms of evidentiary value, like I said that the case law exhibits like an increase in the evidentiary value, but we visit in the case of the Jewish wife, the civil courts said that for Jewish wives, we will have a new level of evidence, which is called light as a kala kenotza, light as a feather. It's enough to even have minor evidence so that the court will believe everything a woman says. So we see here like lots of innovations in the case of the Jewish wife that we don't see in the case of the Muslim wife. On the contrary, the bad things in Jewish laws they copy to the Muslim women, and for Jewish wives they find other solutions that they make up. So still the case of Muslim women is extremely surprising and inexplicable, except for what we try to suggest that goes to Orientalism as well as lack of access. But I must say that those judges that that hold these decisions are not only Jewish. Many of them are in fact Arab Palestinian judges who get those cases. And so they know Arabic quite well, I would say. It's their first language. They have a very good access to those cases. And still we see this inexplicable case law. But I agree with you, we agree with you that this is part of the reason. In terms of accessibility and methodology, so we indeed had access to a very generous database of the Sharia courts. We had like a few hundred cases of wife maintenance, like close to 500. But on the other hand, the sample size is meager when we take a look at the civil family courts, because we are dependent on the discretion and goodwill of family judges to decide which decisions, if at all, to publish, because the Israeli court administration does not officially publish those decisions. So we only have like a few dozens. But Musa, per your question as to how to compare those tribunals, we also had access to unpublished cases that we received from lawyers who shared with us decisions that they were involved in. And we could tell that there were no discernible differences between the published case law and the unpublished case law. If at all, the unpublished case law was even worse in terms of sensitivity to women's rights. So we see that both the published and unpublished decisions speak with the same women-unfriendly voice. And to your other important comment, you're basically urging us to decide how we define equality, whether we define it in formal terms or in substantive terms. But I will say just this. First, don't forget, and of course you, plus all of the people who sit here know, because Musa is a world-known expert in Islamic law, and particularly on the Sharia, on the Israeli version of Islamic law. Islamic law is a system of rights and duties that tries to balance the rights and duties of men and women as a couple. So maintenance is one of the few rights that a Muslim woman has. So we must bear this in mind when we try to interpret this right, and when we dare minimize it. And also, we are not talking about equality per se. We are talking about what Islamic law grants women and what is the range of the interpretive maneuverability that we have at our disposal. And so, I know that you wrote about wife maintenance, that you think that this case law is in fact a discrimination against men, that you wrote that actually discourages Muslim women from participating in the labor force. But I think that this kind of characterization kind of downplays the really low status of Muslim women in both the family and Israeli society. So I think that what the court does is sheerly harms women. However we define equality, this is actually a simple case for us. In the case of Jewish women, there is much more room for deliberation. But in the case of Muslim women, I think that there can be no justification for the judicial trends that we in fact witness. Would you like to add?
No, I think you said it all. I think we should give some of our...
Sure.
It seems to me that when you call on people, you should not call on people who made presentations. Listen closely. Did you hear that? Everybody who's spoken has made a presentation.
They were answering the question because they're from the...
And now time is over. No, I don't want to speak.
No, we'll extend.
Did you listen though?
No, meaning it's good.
Everybody who spoke made a presentation. And
Because they were answering his objection.
So I would like to ask first Ruti. You mentioned my own previous writing about cohabitation, and one of the questions that I raised in the past was whether de facto couples are rejecting marriage, and maybe they reject also is the legal commitment of marriage, and then apply marriage law on those who reject marriage is something that doesn't respect their own choice. And in Israel it is more complex because we have to screen between those who are not allowed to get married or those that reject the religious aspect from those who reject a civil aspect as well. So my question is whether in your initial finding you can try to figure out which kind of cohabitants or motivation are dominant in the cohabitant in Israel, and specifically it is interesting about those who made a private ceremony. What does this private ceremony teach? Do this reflect that they want kind of institutionalization, or the opposite, that they don't want to make it legal, but just something more social? So it is interesting to hear if you can add to the debate about this issue. And regarding Karin, there is something confusing about maintenance. And this is the interaction between maintenance and divorce. Because one aspect of maintenance is what Ram calls the religious aspect. Like, there is a code how people should behave in their own marriage, without connection to the court. That as a moral duty or as a religious duty you have to provide your partner. But when we are talking about court, so during an ongoing marriage, most of the time the issue of maintenance is meaningless. It become a meaning as a temporary remedy before the divorce, or in the case of Jewish law, as kind of pressure about the ones that don't want to get divorced, so you can increase the maintenance or decrease it, and to push them to behave in the divorce situation. So what was missing in your lecture was what are the divorce background in Islamic law and how this law interact with the maintenance issue, and if you can add something about it.
I had three questions. My first is to Pamela. I wonder if there's a huge structural difference between systems that view parenthood as a duty or an obligation and systems that view it as a right. In my experience, both sitting on Bate Din in America and sitting as a special master appointed by a judge, there's a structural difference between the American model of parenthood as a right and the Jewish model of parenthood as a duty, which is glossed over and might form the core of the real distinction that you hinted at but didn't explicitly discuss. My question to Ruth is, isn't it inevitable that this is going to lead to the return of de facto polygamy? And maybe de facto polygamy is already here. I have a few friends living in Israel who are de facto polygamists. And I wonder if the grandeur of the marriage arrangements mean the state will not be able to regulate people having more than one partner at a time. You do a betzibur to one and marry to another. I'm not against the return to polygamy. I know you are. I'm not. It's not for me, but for others it's okay. Karen, my question to you is, does Islamic law allow regulation by contract of maintenance so that there's a way for couples to agree in advance as to what the maintenance will be? And maybe the process of regulation by contract is part of the process of bridging this gap. I don't know enough Islamic law to know if that's possible. Certainly in the Jewish tradition, in America, we undertake to regulate these things by contract. That helps smooth over the gaps between the traditionalists and the moderns.
Okay. First of all, thank you for all the presentations. I profited very much. As I'm strange to the Israeli context, I would like to ask you, Ruth and Karin and whoever talked about it. Is there in Israel no discussion at all about the civil law? So in Palestine, I know there is a discussion. It has no chance of being now implemented, of course, but the women organization pressured for a civil law, try to pressure for a civil law. They are not on a very firm position, but anyway. Then I'd like to add to Musa. You say this is Islamic, Bahra is Islamic, and it's Islamic law. Yes, of course. But just consider that this, what is called normally the maintenance-obedience relation, is not only Islamic. It has also been there in the pre-modern Christian law, for example, in Germany. The husband pays and the woman has to obey. And this is something which has been there for a long time. In Germany, even after we had our constitutional law with equal rights for men and women, there was still a family law which gave the husband the right to be the head of the family, and the woman had to obey and could not, for example, sign her contract. But now this has changed in 1977. It needed more than 20 years after the constitution to change. But anyway, I think this is not so much religious, but patriarchal. Anyway, and comment to you, Ruth. Thank you very much for the highly interesting aspects. Just one comment from the German position. We have civil marriage, of course, and we still have, of course, the religious ritual. So you have to marry in a civil office, but then you can go to church to wherever you want. But now we are developing kind of secular rituals. That means persons holding speeches in marriages which are not anyhow linked to religious things, just completely secular for those persons who want a ritual too, but do not want to go to the church. And of course, this has a history before it. This might be interesting for you from the GDR, from the German Democratic Republic, from the old states when we had 2 states in Germany, and they had, of course, only civil marriages, and they invented quite a lot of rituals, secular rituals for everything which was religious. So which you have a bar mitzvah, I think, or we have it with confirmation. In religion, there was a secular thing. So this might perhaps be interesting. Karin, thank you again for this highly interesting talk. There is one thing I did not understand, and perhaps you can answer it. Now, is marital rape punishable now or not? Rape in marriage, is it punishable or not? Because it's has been a difficult discussion. And in Germany, for example, it became only the law that it's crime in 1997, I think. So very late. So it has been a long development, even in a secular context. So it would be interesting to know this.
The 80s. Ever since the 80s, it's a prime issue.
Okay. Also in religious marriages. So
yes.
Yeah. Okay.
Every marital rape is punishable.
Okay, that's highly interesting because of course nowhere in any Muslim country this is so far the case as far as I can see. And with regard to the civil courts, which are highly interesting for me and which you described in their problems, of course, if you see it from the outside, there's a big problem too. So from the Palestinian side, the courts would never accept it. They have a problem to accept the decisions of the Israeli Sharia courts. And because there are courts in Israel and from the other side. But of course, from civil courts, it would be even more difficult. If you're interested in this, I can just give you an article which will come out soon from a Palestinian also. Okay.
Thank you all, but my question is very punctual to your tripartite presentation. I'm quite puzzled by this split between, on one side, the marriage and divorce, and on the other side, all this maintenance and status of women during and after marriage. Because for me, this is also, it is not Orientalist as such, it's a very Western, Christian-centered approach to the ceremonial. Go back to what you're saying, the priest approach, like the marriage is a ceremony, and then the whole substance of it can be dealt with another court. There is something bizarre in there that I don't understand. So you mentioned that it was initially to give women more kind of equality, but I don't understand the distinction here. For me, it's very artificial, and I'm a political scientist. I sense here some kind of political motivation more than a legal one in favor of Muslim women.
I can just say in defense that we adopted everything from the Millet legal system we inherited from the British and they inherited from the Turkish, from the Ottoman Empire.
You can start by Karim. Which one? We can answer briefly.
Are there any more questions?
No, just answer now.
We should finish.
Yeah, we should finish.
Brief answers, please.
Oh,
Brief answer because if you speak more, you will eat less.
No, everybody's going to hate me. I'll just say, Shachar, that you prove my point when you asked me about the relationship between maintenance and divorce, and you said, oh, this was missing from your presentation. No. You would think that this is a missing part only if you come with a Jewish law hat and you think about, again, Jewish couples. That's exactly what the judges do. They take a look at Muslim couples and all they see is like Jewish couples, sometimes in reverse, but there is not the same relationship between maintenance and divorce like we are used to in Jewish law. This is not part of the battle because it's easy now these days. It's easy for both men and women to apply for divorce in the Sharia courts. It is easier for men, to be sure, but for women it is much easier than any other religion in Israel. So they don't need to use it as a leverage, so we don't have those kinds of tensions. Why is it important to get maintenance? Because, Shachar, you forget, Muslim women, most of them, I'm not trying to essentialize all Muslim women, but as statistics tell us, they are the poorest segment in Israel, except for the Haredim, the ultra-Orthodox. They really need the money. Many of them don't work, and when they do work, they earn not a lot for living. They really need it in order to survive, and they usually live not on the houses, not on even the husband's house. The house is registered on his family. So when they divorce, she hardly gets anything. She can be married for 20 years and leave the marital house empty-handed. So she really needs this maintenance. For her, it's survival. When we I can go on and on and on and on about it. So marital rape became
Continue discussion.
Okay. So I'll give other people.
So now,
Ruthie, do you want to?
So we can continue, all these questions over lunch. So just, Irene, of course there is a discussion, thank you, of civil marriages in Israel. It's more political discussion. Legal scholars have also written about it. Shachar has also written about it. We are part of the center that I'm heading up, part of the coalition for pluralistic marriages in Israel, but that's, again, it's a different topic. What I focused on was within the existing legal framework, what's happening, again, top, bottom, and bottom up. Shachar, to your question, we had a question within the empirical research about how the couples actually perceive their relationship under what structure, what system do they see themselves as abiding by? Is it the religious system or is it the family legal system? But what's very, very clear is that once they actually engage in a ceremony, that is a clear indication that they see themselves, they definitely see themselves as married, and they are seeking, in fact, the social legitimation of others seeing themselves as married as well. And as to the question of particularly, is it the religious norms or other norms, that really varies within the different types of these specific private marriages that they conduct. As to the question of de facto polygamy, well, I'm very familiar with these arguments. This is the situation anyhow within the existing Israeli legal framework, which is really exceptional in recognizing the de facto relations, even if one of the couples are already formally married to another, regardless whether that marriage is dead or even existing. And that's an outstanding situation worldwide, which is really very problematic. I think it is problematic, but this phenomena of private marriages, I don't think it adds anything empirically, practically speaking, to the already existing problematic normative framework in that respect, in recognizing the de facto polygamy in Israel.
Thank you. I think we have a cake break, not a coffee break, and we are very beautiful. So, 10 minutes, you know?
Yeah, we'll try to start at 12:45.
Okay.